Hello, and welcome back to A Little Privacy Please, the weekly series where I break down what matters most in data privacy without the noise. I'm Julie Rubash, General Counsel and Chief Privacy Officer at SourcePoint by Didomi. This week we have two stories from different parts of the world. In the US, New Jersey just became the third state to enact a surveillance pricing law, adding another piece to a patchwork we've been tracking all year. And in South Korea, regulators fined TikTok and Apple for lacking a legal basis for processing. Let's get into it. Let's start with New Jersey, where the governor has signed the Fair Price Protection Act, making New Jersey the third state after Maryland and Connecticut to enact a surveillance pricing law. A fourth, New York, is currently sitting on the governor's desk. At its core, the law bars grocery sellers from using personal data to vary pricing across consumers, whether through algorithmic pricing or data pulled from cameras, sensors, biometrics, or device tracking. It also includes a purpose limitation rule prohibiting the use of data collected for one pricing purpose from being reused for another purpose without consent. There are exceptions. Companies can still charge based on genuine cost differences, like delivery distance, as long as pricing doesn't change more than once every 24 hours. Publicly disclosed, uniformly applied eligibility discounts, like teacher or veteran pricing, are also fine. And loyalty programs are unaffected, provided enrollment is voluntary and terms are consistent and disclosed. New Jersey's law is actually narrower in scope than the others. Connecticut applies generally to all tangible retail goods. Maryland pairs a food sector prohibition with a universal disclosure rule, and New York, if signed, would cover all goods and services. New Jersey applies only to groceries and foodstuffs, with restaurants carved out. But within that narrower lane, it's the strictest of the four in three respects. It's the only law with an electronic shelf label moratorium, which applies for 1 year starting next February. It's also the only law banning personal data-based grocery pricing outright rather than just algorithmic pricing. And it's the only law to codify the purpose limitation rule explicitly, although that conduct may already be covered in some states under the general purpose limitation principles found in their comprehensive privacy laws, as California's recent surveillance pricing sweep suggests. So, for grocery and food retail companies, if you're already compliant with Connecticut and Maryland, you're most of the way there for New Jersey. But revisit any manual, as opposed to algorithmic methods to vary price, and any shelf label rollout plans specifically, since those are the areas where New Jersey goes a bit further. Now to South Korea, where the Personal Information Protection Commission, the PIPC, issued two fines, both resting on the same violation: processing personal information without a valid legal basis. TikTok was fined roughly 10.3 billion Korean won for failing to clearly notify users at sign-up that it was collecting their activity across third-party sites and apps, and for collectively conditioning app use on accepting that tracking, which undercuts voluntary consent. Apple Distribution International was fined around 252 million won based on a finding Apple used voice recordings and transcripts for voice recognition and search improvement without separate consent for those uses. The TikTok decision in particular reinforces a position the PIPC has already applied to Google and Meta. A platform tracking its own users' off-service behavior can't hand off consent responsibility to participating sites and apps. It has to establish its own legal basis. The PIPC rejected that same delegation argument in the Google and Meta cases, and the Seoul Administrative Court upheld the sanctions. Now, for companies thinking about how this compares to Europe, the GDPR doesn't let platforms disclaim responsibility either. A platform can't just point to a publisher's consent banner and call itself covered. The EDPB has allowed joint controllers along a data chain to rely on consent collected by the first-party controller in contact with the user, though, provided all controllers are named and separate purposes get separate choices. The PIPC hasn't ruled that out, but hasn't explicitly endorsed it the way EU guidance has either, which is a gap in enforcement certainty worth flagging for companies operating in both markets. So for now, the conservative position is not to assume a GDPR-compliant joint controller consent chain satisfies Korean requirements, and instead confirm your platform is independently obtaining valid consent for its own tracking. So, two stories this week. New Jersey adds another entry to the growing list of state surveillance pricing laws with requirements like the shelf label moratorium that go further than anything else on the books. And in South Korea, the PIPC fined TikTok for pushing its own consent obligations onto third parties, and Apple for continuing to use previously collected voice data without establishing a legal basis for that use. That's it for this week. As always, you can find more details in our newsletter, A Little Privacy Please. I'm Julie Rubash. Thanks for joining me, and I'll see you next week. Until then, go enjoy a little privacy, please.